This lesson outlines the options for sentencing, criminal sanctions, what happens once a person is found guilty or has pleaded guilty in court. In summary, I'll be talking to you about the purposes of criminal sanctions, the guidelines for sentencing, what the judges need to take in consideration, the factors that affect the sentencing decisions, the options that are available to judges and magistrates, and are they actually effective? Let's make a start. First of all, let's talk about the purposes of criminal sanction. The first one is the old one, eye for an eye, the retribution angle. The society wants to, in another word, punishment is a consequence for having done wrong. It is also there to deter people from doing the same thing again, or indeed deter them from doing it in the first place. The sanctions imposed for various crimes. Sanctions are aimed at discouraging other people from committing similar crimes. Rehabilitation. That's the one that people talk about the most, and in a lot of cases fail to deliver. But what we want to do is to rehabilitate a person so they become a better person once they come out of jail. So the hope is once they become rehabilitated, they'll be able to assimilate into society and not reoffend. Protection. Some people need to be put into jail to protect the community so that they don't commit any more offences, and that in an extreme case is what happens in very violent crimes. The last aim of punishment is denunciation. It basically says that the criminal justice system is disappointed and wants to send a message. So, for example, the judge may give a harsher sentence for particularly violent rape and make comment as to how the court is showing disapproval from this type of behaviour. For judges and magistrates in Tasmania, there's guidelines for sentencing. They're all set out in the Sentencing Act of 1997. These are the sort of things that are taken into account. The prior criminal history, the age of the offender, so when they're younger they try their best, or they being the judges and magistrates, try their best to give the person the best chance. The circumstances of the offence and the motive of the offence. The background and certain personal circumstances of the offender, where there's a social disconnection, then that is taken into consideration. The prospects of the offender being rehabilitated, so there's every chance given in that area, particularly when they're young. Will it be a personal deterrence? And will it be some sort of retribution? So will they feel retrition from the act, and hopefully they won't do it again. Now let's look at some factors affecting sentence and decisions. Aggravating factors increase the severity. There can be things like they played a leadership role, if they are a repeat offender, if they didn't show any remorse. The opposite way, mitigating factors, if they were coming from a disadvantaged background, or if they showed remorse in terms of what they've done in the trial, then that can mitigate the sentence given by the judge or magistrate. What are the options available to judges and magistrates? The most severe one is imprisonment with conviction. The second one is a drug treatment order. This is a supervised drug or alcohol treatment program, and it's only available if a person actually pleads guilty, or whether the magistrate thinks the offender is dependent on drugs or alcohol. The next one is suspended sentence with a conviction. So the sentence is suspended with good behaviour, and if that person reoffends, then they will serve the suspended sentence plus the one that they may get for the reoffence that they commit. So under a probation order, the defendant is under the supervision of a probation officer for up to 3 years. So that means that the probation officer will be in contact with the person to ensure that they assimilate into the society. In addition, the offender is usually asked to attend training and other programs to try and rehabilitate them best way possible. Community service order is a bit similar to probation. It's where they have to give some sort of service or engage in some work up to the maximum of 240 days, which is hours, 10 days. And they're usually known as work orders. A lot of the time people are straight fined, for example, driving offences and so forth. This is similar to the community service order, where they're ordered to engage in some sort of program to rehabilitate them so they can best assimilate better into the community. We'll also get an adjournment with conviction, and that conviction only lasting 5 years, so things are dismissed, but bit similar to a suspended sentence. So the conviction will be there for 5 years, and if they don't reoffend, then that is struck from the criminal record, and they can obviously be discharged without any conviction whatsoever. And the last one is where the offender can be totally dismissed, obviously without conviction. There's some other sentencing options which are not yet used in Tasmania but other jurisdictions like Victoria, namely periodic detention. So that means that only say during the week or on weekends, which are the way it works, people are detained. Also got this thing about home detention where people have tags on their ankles, so that with GPSs, so they know the authorities know where that person is. When a prisoner is of good behaviour while they're in imprisonment, they've got a certain period in which they can apply for parole, which can shorten their sentence, and these are usually set down by the courts. And lastly, dealing with young adult offenders for the Youth Justice System. Our Youth Justice Act of 1997 deals mainly with what we call restorative justice, and their main aim is to get the offender to be rehabilitated as soon as possible. Dealing with young adults offenders through the Youth Justice System of 1997, it involves this concept called restorative justice, which is an approach that focuses on the needs of victims and offenders rather than concentrating on punishing the offender. So there's a meeting between the youth and the person that they have impacted, and try and restore the situation, and so they can see what impacts they've had on the actual victim, and the community can be involved in this process to try and restore the person or the young offender back into the system, and with the hope of keeping them out of the criminal justice system. To the last section here, sentencing options. Are they effective? Which aims do options address? That's something that you can do with each one of the options that I've outlined earlier. They're also well set out in your textbook. So, for example, which aims does imprisonment address? And that in a lot of cases can be a moot point. In Tasmania, there's this thing called the Sentencing Advisory Council, and what that aims to do is to try and keep up with the trends and what happens in society, and here are some main aims of this council. So they undertake research, they try and be better informed, inform the public on crime and sentencing issues, to gauge their opinion, and also to give advice to the Attorney General and other agencies in relation to penalties and other sentencing matters. I hope that's been useful to you. If you have any more queries, then the textbook in chapter 8 is very relevant, but it is Victorian based, and the aim of this lesson was to make it totally Tasmanian based, and there are some subtle differences that you'll note when you compare what I've just told you as opposed to what's in chapter 8 of your textbook. Thanks for listening.